Hey everyone, Brian Fouts here.
And I'm Jake Fouts.
And we're here with Kevin Day.
Hello.
Appreciate you being here, Kevin.
Love being here.
Yeah. We're going to be talking about wills and trusts today in the Foundation series. If you haven't already checked out our intro video for asset protection and foundation, go ahead and take a look at that video. But today we're going to talk about wills and trusts and how they apply to pretty much everyone. And this also applies to people in the U.S. and out of the U.S., whether you're in Canada, the U.K., wherever. Kevin is very familiar with working with anybody around the world, so this is not just for U.S.-based people. But for wills and trusts, as I stated in the original video, I didn't have a will or a trust when I was starting out as a W-2 employee. I knew about a will, but I didn't think I had to have one. I didn't even know about a trust when I was starting out in my career when I was in my early 20s. But I mentioned before, I got my first trust, my living trust, when I was in my 30s, I believe early 30s, and I already had a house and assets and cars, and before that, they weren't protected at all from probate, or if I passed away, they'd be stuck in probate for possibly 2 years, and I didn't even have a will, and yet I had family. So I went ahead and put that in place, and so I wish I'd had that information when I was younger, such as everyone's getting this information now. And correct me if I'm wrong, it doesn't really matter where you're at in your life. You could be, later on in your career path, have a business, have high revenue, but I've met a lot of people that don't even have that basic will and trust and asset protection in place.
Oh my gosh. Most people know about wills. They've heard trusts, but they've gotten wills from old Western movies and stuff like that, so they have a concept of what a will is. And even then, it's something like 20% or less of all Americans have a will, and even fewer have trusts when they absolutely should. And part of what our EVG education is in this segment is going to be is about the thresholds. And different states have different thresholds, but why would somebody want a will? Why would somebody want a trust? And if you don't have either, what are the repercussions?
Okay, all right. So we're going to go through just some basics of wills and trusts in this video, and why you should have them. So appreciate you being here, and this is going to be a great topic.
Fantastic. So we don't like contemplating our deaths. It's human nature that we're always prospective about how great our life is going to be and how long our life is going to be. Unfortunately, we're all in that conveyor belt, so we have to be a little bit pragmatic. People that don't even have it on their radar when they buy a home, or when they have a child, or the second child, or the second home, they think about it. And sometimes they don't get off the dime, because usually when those events are happening, they're a big deal in the family. And even though it pops up in consciousness, they often get swept away by this new part of their life that takes energy. So when you think about it, you really need to take the bull by the horns and get it done, because we all know we're going to die at some point. So what happens when somebody dies? Your world freezes, and nobody has authority over it other than the government through a will or no will. Or if you set up a trust, and that's what a revocable living trust is about, is setting up a mechanism that you are appointing in advance of your death who the court hopefully will end up appointing, and you pay a bunch of fees to a lawyer to get that same person appointed by the court. So that's what a living trust is.
And you can't do it after the fact.
You can't do it after the fact. So when somebody dies, their world freezes, and if they have no will, there is a pre-proscribed government formula of a family tree of who will get what. So if I die and I don't have a will, they'll say, does he have a spouse? And if yes, she gets it all. If I don't have a spouse, does he have children? And the children will get it. And if they're grandchildren, they will get it if there's no children. Now, if I have 3 children and one has died and I have grandchildren of that, they won't inherit, because the family tree only goes to the first level. If I have no children and grandchildren, then do I have any parents still living? And if they have passed, Do I have siblings? And then nephews and nieces. So there is a pre-prescribed manner. So if you have a very small estate and you have no children and you have no spouse and a small estate, you can probably get away with not having a will. There's a pre-prescribed, if I get hit by the bus and I don't have much, then my parents will get it. But once you have children, you want to start to prescribe and control. It's all about control. Estate planning and business planning and financial planning is saying, I don't want the world just to fall as it may. I need to take control over my life and put these tools into place. So if you have a will, that means that's an instruction to the court. But you get to have control and decisions. Like, if I die and one of my children has passed away, but I have grandchildren, I would like that third, in my example, to go to the grandchildren. I don't want it just to go to the surviving children and the grandchildren of my two other children. Right. I don't want to worry that they will somehow allocate something to that third of my family. Also, I don't want 18, 19, 20, 24-year-old children to get $1 million or several $1 million. And so in a will or a trust, you can put conditions of inheritance. If the estate starts to have some size also, my wife is beautiful, and she's going to get swept off her feet by the handsome tennis instructor. So I don't want my kids disinherited. So half of the estate will take care of my wife. The other half will also take care of my wife, but be quadranted off so that it will go down to my children. And so there's all kinds of conditions that can be put into a trust or a will.
Now, so you're using the terms will and trust.
Yes.
But they're different, but they're also intertwined. Because I believe I have to go back and look. It's been years now.
If you have a trust, you also have a will.
There we go. Okay.
Okay.
That helps.
But if you only have a lot of people can only have a will or only just want a will.
Okay.
So the will allows you to put conditions on the inheritance, but you still have a probate.
Now, probate that's government control, essentially.
That is government decision on how your assets will be allocated.
And for EVG and a lot of the members, what we're all about is actually controlling our lives, which means not having the government control it.
Exactly. So what happens through the probate process, with or without a will, is that you're going to be paying a lawyer, and you're going to lose 6 or 7% of your estate through that process. Will typically takes a couple of years, even a simple estate.
Go through probate?
Probate.
Okay.
Yeah, so going through probate will take a couple of years. And then some states are even longer. California is horrendous.
Now, if you have to go through probate and it takes that long, and yet your family needs their assets or something to survive on, do they have to wait that full 2 years to even?
They have to petition the court. So if my mom died and she only had a will,
okay,
I can't go down to the bank and say, here's my mom's death certificate, here's my birth certificate. Not only am I the loving son, but I'm also an estate planner. I know what I'm doing. Put me on her bank account so I can pay her mortgages and pay her bills and run the estate. Instead, we have to go ask the probate court. When the probate court gets a will, they actually don't do much with the will for about 9 months. So the first 9 months, they have not appointed what used to be called an executor or an executrix. So we'll say executor. Now it's called a personal representative. They give time for my sister and other relatives to come forward and say, yes, Kevin's the right guy, or Mom hated Kevin. He's the wrong, she would not want him handling her affairs. Or she loves him, but he's a financial idiot, don't give him. So not only my family members, but her friends. So for the first 9 months or so, it's a determination, do we have the right person that we're going to give the authority to? And in the meantime, the bank doesn't care that my mom's died. They still need to get their mortgage payment. The insurance still need to be paid. All these things need to be paid to run the estate. So now not only am I paying some lawyer 6% to talk to the court and guide me, the court is also going to appoint a court-appointed trustee that you're familiar with at $200 an hour to pay my mom's bills.
And that's all public knowledge too. That's one big thing about a will that's going through probate that's not protected. We'll get into a trust here in a little sec.
Yes.
My understanding is it's public knowledge. So predators, financial predators, can actually see people's estates that are going through probate and can essentially attack them.
Absolutely. You have no probate is like any other court case in America. So if you go down to the probate court, there's usually a bunch of picnic tables with a bunch of young people scribing away, and they take that file, they go back up to the clerk and get another file, and they go scribe away. What do you think they're doing?
Getting public information?
They're mining, they're getting public information. So in there, it will say, particularly wills, they'll say, Billy's getting the cabin up on Mount Rose. Sally's getting the 2 rental homes, one in Georgia and one in Colorado. My savings account, which is $300,000, will be split equally between them, or whatever the conditions are. These people now can contact Billy and Sally and say, probate takes 2 or 3 years. We can come and buy that cabin up on Mount Rose. We can bring cash tomorrow. We will pay you that $90,000 for that cabin. And that cabin is worth $250,000. Right. Even whenever you hear in the newspaper, usually it's stars or ball players or something that, they had the exact dollar amount of the estate and who's getting what, though it's because it's all listed in the probate. Every penny and who's getting what.
So just as a question, if you have a will, does it still go through that probate process?
Yes.
So that stuff we're talking about is still public knowledge, and they can still go down there and look at that and call you up if they want, even if you do have a will.
Yes. So a will is an instruction or request to a judge. A judge they're usually going to follow the will, but the process, it's really archaic. It's meant to allow people to challenge the estate. It's archaic. It's time to get notice by wagon train back to Boston that the uncle died, so she can come out and say, no, I was his favorite niece. Here's the letter. I was supposed to get 40 acres of the ranch.
And this is where you hear a lot of stories about like an ex-wife or someone who will then say, oh, my husband died, he remarried. They come and attack it, and all of a sudden, rather than being in the probate for 2 years, correct me if I'm wrong, I've heard stories about things being tied up for 5 years, 10 years.
Absolutely. And the other thing is, when people are married and then get divorced, they forget to void their old estate plan and do a new one. There are hundreds and hundreds of cases where people have been happily married the second time, or maybe even third, let's just say second. 15 years later, they die, and somehow this will or trust comes up that says, I'm leaving everything to John or to Mary, the first one. That, usually they're acrimonious, not always, but they're usually not the person that they want, and it's the last thing they think about. They have to be, they've forgotten. Again, we don't like contemplating our death, so we do our estate plan, put it on the shelf, and forget about it, and then we go through the rest of our lives, and you have to continue to think about it.
Right, and it doesn't matter if you have a house worth $100,000 or a house worth $10 million. Protecting that from financial predators is what we're talking about here.
Exactly.
And it doesn't matter if you're worth $100 million or you're just starting out in life. I mean, that's what I learned when I first started getting into it, and I realized, well, I actually own a bunch of assets. I had no plan, no will, no trust, nothing, and I was very open to that if something happened to me.
So especially if you have a child, you don't want them, even a small estate, you don't want them to get $100,000 when they're 18. Either they're going to do something stupid with it, or their friends are going to, oh, let's go to Europe, and then it's gone, poof. So if you have one child, you really need at least a will, even if you have a small estate. You want to set up guardianship provisions. That's in a will. It is not in a trust. That's why, there's two reasons why when you have a trust, you still have what's called a pour-over will. If you forgot something, it gets poured over, P-O-U-R, like a pitcher, poured over into the trust, but it also holds guardianship provisions. Because again, you don't want the government deciding who's going to rear your children. It's actually, if you have children, it's the most important part in my mind of your estate plan. I hope my sister never watches this. My dad was a 6th grade school teacher down a little town called Delmar. And my sister became a teacher. She's a lovely person. I went to the dark side, became a lawyer. I get my teaching fix by working with you guys, being a professor, faculty. So she's great with kids, but she has a very different perspective on life than my wife and I. We would not want her to be the guardian of our children. My wife's family is from Michigan and Iowa, salt of the earth, strong work ethic. Any single one of them would be a good candidate. If we didn't leave instructions, the court has 25 other guardianship decisions that afternoon, and one of the family members come up and say, I've got extra rooms in my house. The judge says, sold. That's easy. Let's get to the next case. That's not how I want my choice of the trajectory of my children's life to go.
Right.
In fact, as I said, any of them would be fine. One of them actually lives right side out of Washington, D.C. in a real mansion with pillars and everything, and all their kids are gone, and they've got lots of rooms. Even when the kids were there, they had lots of rooms. They would be fine. But the one that we actually chose was the sister that works at Home Depot, and her husband is a handyman, because they have the special essence about the view of life that we think would help our children the most.
That's awesome.
Kids don't care. They can live in a pup tent in the backyard. They want love, they want education. And so the people that are going to be surrogates for Susan and I are going to be the people that we think are going to give that the most. We're going to sell our house, they'll have rooms. You know, you don't want a judge making those decisions. Right. And that's in a will.
Okay. And so when you're talking about a trust, though, a trust is similar but different.
Okay, so this is a loose analogy, and you're going to need to listen to, if you aren't familiar with corporations, you'll get this in those segments. In a company lives independent of its owners. So right. If the president dies, you don't run to the storefronts and say, put close signs up, stop the machines, stop the presses, the president died, we can't run until we have a new one. And we have to get all the board of directors together to get a new president, so we can't do business for the next week. But that's what happens with your life. When you die, if you don't have a trust, and it's the only mechanism will do it, it puts into place who can carry on the business of your estate. So in law school, we drew a trust as a triangular box. And we had the person that originally owned the assets. I'm going to make a husband and wife here. They originally owned their home and their car and maybe a rental or two and some savings accounts. And it's owned in their own name. That means when they die, with or without a will, they have a probate. They have to go through the government control and the cost, that 6%, 5%. It's a sliding scale. It starts at 7% for the first couple of millions. It's a horrible event. What we want to do is change title into the name of the trust. So it's going to be the Day Family Trust. Now these are called settlors or sometimes grantors. And then there's beneficiaries. So in my case, Kevin and Susan are going to name themselves as the first beneficiaries. And they're going to name themselves as the first trustees. So what we've done is, I notice I wrote 2 lines going in, but 1 line splits. This is very relevant in the section that you're going to have on lawsuit protective trusts or irrevocable trusts. Here, it still is important, but not as critical. But what that's done is I've changed title to this thing that can live beyond my life. So when Kevin and Susan die, we have successor trustees. We're the first trustees, but we have this list of backups that when we die, they're in place. If they're dead, we have this succession. And when we're no longer here, our backup successor, or the successor beneficiaries are our children and some charities. So what occurs is at our death, we already have a preordained, in the analogy of a company, it's already written in the articles who the new president's going to be. And this successor trustee has absolutely the same power as the original owners. So in the example of my mom is 92, she's a totally cool lady. She's living alone, still driving cars, and I'll call her up for lunch and I'll say, hey, can you go to lunch? She said, no, I'm driving the old ladies downtown. The old ladies are 70-year-olds that don't drive anymore. They'll call her and say, we want to go to the museum. We want to go out to lunch. My 92-year-old mom does this stuff. It's crazy. But she's going to die at some point. And I can take this document that's the trust that has the magic language that the state requires and a death certificate and go down to her bank and they will put me on that bank account that day. I can start writing checks and running her affairs instead of paying a lawyer and going to probate and waiting 9 months to be appointed as the executor or the personal representative.
Wow.
And so this is a way to avoid probate.
And
you
yes.
don't need the government's, you don't need the judge's stamp to get to exactly where you know you want to get anyway.
So in that scenario, when the settlers pass, does this go through the court at all?
No.
So just probate is pretty much...
There's notice requirements to certain blood relatives that have to be noticed. You have to put notices out for creditors in either process. So there is some procedural stuff, but you don't need the government's authority. And it's a closed universe. There's no privacy issues. Even with this trust, when my dad died, there was an enterprising entrepreneur. As I said, my dad was a 6th grade school teacher in this little teeny town that's 28 streets by about 8 streets. And some enterprising person looked at the obituary in this little Del Mar local paper, and my mom got calls, not during dinner time. My mom got calls at 2 and 3 in the morning by people saying, oh, Mrs. Day, we understand that your husband's passed. It must be a very tough time for you financially. We see that there's some real property. So even though there wasn't this whole line that Billy is getting this and there's all these things, they were able to find my dad's name as trustee of the Day Family Trust, and there were several properties. We'll come down and pay you tomorrow. Now, you just heard my mom is very cool, for her 85th birthday. She went, hang gliding and stuff. They got an earful, but these people are predators. It took me 4 years to figure why they were calling at 3 in the morning. They have the audacity to do that. It's because all the gatekeepers are gone. All the family members have gone back to the hotels. My mom's up in the middle of the night bawling her eyes out, you know, and these people will take advantage of that. Yeah. We have privacy enhancements that will help with that as well. But there was a burglary ring down in Texas. It took them about 3 years to figure it out. These wills were road maps, treasure maps. They would say, Sally's getting mom's diamond ring, engagement ring, Aunt Bertha's emerald brooch, and some other gold jewelry. And I keep that in a sock in my brown shoes in the right side of my closet.
Oh,
the gold and silver coins that my grandfather started and I continued to keep are in the red and blue binders in the office up on the shelf. The negotiable bonds are in the third drawer down. And so these criminals, these burglars, had a roadmap of where things were. The family, when somebody dies, you have to write an obituary, you have to call all the relatives, you're just trying to figure out what bills are supposed to be paid, not paid. The burglars were in and out the first couple of days. Then they go to the will and they go, okay, let's go look for it. Oh, well, the gold coins are gone and the jewelry's gone, but Dad was old. He probably moved them somewhere in the, they're pawing through everything in the house. So all the evidence, the fingerprints and stuff that they would have been able to get is all just totally messed up. So they weren't getting the evidence. Then they started to realize, what happened, and they finally caught the ring. But privacy, is important to us, and we have simple avenues to take care of that. However, our job isn't to make the decision for you, but to educate you. So where would you want a will rather than a trust? And it really has to do, most of you have heard that if my estate is smaller, there's an abbreviated way through probate, and that is correct. But the threshold is miserably low. Most states, it's 25,000. About half of them are 50,000 and below.
That's the value of the estate?
The entire estate.
Okay.
Washington, your state, is actually one of the higher ones. It's 100,000. California is $150,000 worth of all property, or $50,000 worth of real property, whichever is leased. You can't own an outhouse in California and have it be below $50,000. So if you own real property in California, you don't feel rich at all, you've got a probate. You want more money going to your kids. You can have a $300,000 estate, and $18,000 is going to go to an attorney, or you can get a trust that's going to be $3,000. You don't like writing a check about your death for $3,000 for a comprehensive plan. It's not just the trust, it's all the pour-over wills and medical directives and guardianship provisions. But that's cheap in comparison to go through the probate process if you're over those thresholds. So you can contact through the website EVG and say, hey, I want to know what my state's threshold is, and you'll get me that information, and we can shoot out that information to everybody on what their state is. New York, it's $20,000. Texas, $30,000.
So could you explain what that threshold is again? That's for the lowest you can have a trust for?
No, this is if you are over, let's say, in Washington, your estate is $90,000 or $80,000. Total estate, your car, your savings, your apartment, whatever. The total is $80,000. You can do a special attestation and an accounting to probate, which means you're not going to have the full scale probate and the whole big long length of probate. But if you're over the 100,000, then you're going to have a full blown formal probate, every single thing is going to have to be approved, and it doesn't get it dispatched. So that means you want a trust versus a will.
Okay.
And you're really not going to, and the only way to know that is actually do an accounting of all your assets all the time. Almost to know what your estate is worth.
Have a ballpark.
Yeah.
But so then the question is, if you're in Washington and you have an $80,000 estate, you're saying, okay, I don't need a will, maybe, because it'll go by, I've got a 3-year-old daughter. Even though I'm only $80,000, I don't want, it'll be set up by the court to be held by a guardian, a fiduciary guardian, but you don't want her to get $80,000 on her 18th birthday. And you can't control it. As soon as somebody becomes an adult, they get all the stuff unless you put a control mechanism. So without a will, you can't control it. So even if you're a small estate, you want a will. And there's 2 ways to do a will. A holographic will, which is the old Wild West thing. You have to write every word of the will in your hand and sign it. Most states require, some states require witnesses, and then the number of witnesses is important. But if you scribe the whole thing, there's a whole procedures about proving that it's truly your hand and everything. And then there's the formal will, where a lawyer types it up with all the magic language that the court is looking for, and it requires usually 2 witnesses, sometimes 3. With that formality, there isn't that big prove up. It's self-evident that it's you and yours and your wishes. So there's procedures to go through, but do-it-yourselfers, you can scribe it out and as much detail as possible and sign it. And if you can get witnesses as well, although it's not required in all states, go ahead and get witnesses. People do that all the time. I'm going into surgery and they'll literally be in the waiting room saying, what happens if something goes bad? And they'll just scribe it away, and then the people don't need to know you. They need to know that I attest that this is somebody's will, and they've shown me their driver's license.
Yeah. So even if you have a trust, though, you can put the will inside that trust as part of what we're talking about, too.
It's a side document. So when we say a living trust, it's in our package, it's actually 11 different documents. Okay. And so the heart is the trust, but the will carries the guardianship provisions if you have minor children. You want to pour over will because some things that should be in the trust never get there. You go to Hawaii, you're at a vacation, place, and you go, wow, this is the cat's meow, and guess what? There's an apartment next door that's for sale, and you buy it and you put it in your own name. You forget to put it in the trust. Often, timing is important. Aunt Harriet dies and leaves 50% of her estate to you, and it hasn't been distributed yet because it's going through probate. It's going to take 2 years. You get hit by the proverbial bus the year after she's died because it says that it's going to, Jake and Brian, and it hasn't been titled that way by the court yet. It doesn't name your trust, and you get hit by the bus, so it comes into your estate. So there would otherwise be a probate on that, and you want to instruct them that it's to be poured over into the instructions of the trust.
Okay. And
that was, for me, that was the first advice I was given, was get a will. The first financial thing you should do is get a will. And I didn't have a whole lot of assets at that time, but the one thing you mentioned was make sure that you get it updated, because that's the biggest thing, because things change in your life. And a lot of people, when I got a will, it was because I think I'm going to die when I'm 75, like you said, and I want to make sure everything's organized. But then, once I had kids and then I was going on a vacation, it was just my wife and I by ourselves. All of a sudden, the week before we went on vacation, I'm like, we better update our will because a lot has changed since the last time we did it. So the advice I was given was go through, like you do your taxes annually. So go through and look at your will at least annually to see what has changed so you can make those revisions that reflect kind of where you're at in your life.
Absolutely. So if there's a law change, the lawyer should be sending out, we send notices to our clients and say, this law changed, it affects Article 9.2, and this is its effect. If you care about that, we have a patch, and it's $250. Every once in a while, the law has changed and invalidated this section. You need to do the patch, and it's $200. The self-reflection, a lot of lawyers say, come in to me and pay me, $50 to help you review the trust. I should know what my trust says and your trust that I've drafted for you says. It's really, you don't need to, if you're disciplined, put it in your calendar with your tax returns, and it's self-reflection. It's not the drafting of the trust, it's, did we have more kids? Do we have grandchildren? Has our estate gotten much bigger, and we don't want to give it all to the kids. We want to hold back a percentage as an education fund for grandchildren and great-grandchildren. Is it big enough? Do we want to give some to charity? Were we really big and now it's 2009 and I've lost a bunch of my estate, so I don't want to give to charity anymore. I just really need to take care of my family. So it's really big things that have happened in your life or your estate that you need to self-reflect. If there's been changes, then you come into the lawyer. I don't think that you need to pay a lawyer to do a review every couple of years. Things don't change that fast. Every 4 years, maybe 5. That's when you might want to go into the lawyer just to have a sounding board, but
Right.
it's really self-reflection.
Okay.
And I know EVG members are self-disciplined. You're getting organized. You don't only want to emancipate yourself from the government, you want to emancipate yourself from the lawyers.
There you go. All right. Well, hey, I appreciate that. That's really informative for me. It actually reminds me of a couple things I probably need to go do in my trust, actually, probably tomorrow. So it's a good refresher.
And these are revocable, which means changeable. So as my kid, my first trust said, kids, if any, we didn't even have kids yet. And we said, take care of moms and dads that are alive, then go to nephews and nieces. And as soon as, the way it was written, it said, the kids of Kevin and Susan will inherit. And if none, then here's our stuff. So I didn't want to have to worry about if we had a child and I was so busy and I didn't really change it until 2 years later. If I got hit by the bus, my kids didn't get disinherited. You don't want to write it as, well, I don't have kids yet, so I'm going to say to my mom and dad, brothers and sisters, because you might have a kid and you don't get around to it. So we need to kind of crystal ball it into the future and make sure that we have allowances to my spouse, if any.
That's especially
to
important
children, if any.
if you have one child and they're going to another family member, but then maybe you have 3 or 4 kids down the road, all of a sudden that may change to who those kids are going to.
Right, and people don't like contemplating their death. So we will draft to all of my legally recognized children, and currently I have Natalie.
Right.
So even if I never change it, the drafter should have been drafting into the future. Because we're also lawsuit protection attorneys, we put spendthrift provisions in this. The regular spendthrift provisions are, if they're a spendthrift, they can't hold on to their money. They have drug problems or alcohol problems. That's the normal 3. We put in if they're going through a divorce, if they're going through a rocky marriage. I don't want my kids to get dumped with these assets that might be commingled or construed as part of their estate that's divisible. So we put restrictions. We're going to be dead. Make us the bad guys. If they have tax problems, I don't want my hard-earned estate, and they might have legitimate tax problems. I don't want my estate dumped into their lap while they're sitting there negotiating with the state authorities or the federal authorities. That's just sucking my money away. And I want it to go to my children and grandchildren. It's your empire. You can put pretty weird conditions on it. I'm not encouraging weird conditions, but I've seen some wild conditions. And part of the good lawyer's job is to get your wish list and say, oh, we've written that objective, we've written 5 different ways. And then you say, oh, we like most A and we like a little bit of C. Can we put those together?
All right. Okay. Well, for a lot of the EVG members, and for me especially, this was something that I wish I had done a lot earlier. But it's a great entry-level asset protection strategy to get in place. Because as you go through your path, building wealth, creating assets, and essentially building your life, this is going to be even more and more important. But this is a great place to start. And if you want to go ahead and get started on this, want to work with Kevin and his team, which we obviously recommend that, go ahead and look at the contact form down below, fill it out as to what you want, and we'll get it over to Kevin, and you can move forward with that. But next video we're going to be looking at is going to be about business entity structuring. So for starting out, if you guys have businesses or want to get in businesses, we recommend watching that video as well. So until then, see you next video.